Welcome to Wills and Trusts. This is Chapter 6, where we're going to discuss the creation of trusts. So far in this course, we have covered how property is transferred at death using wills or through the application of intestacy rules. So we've looked at how wills are used. We've looked at how intestacy rules are used. We're now going to look at another mechanism through which property can be transferred at death, and that is a trust. So this video is focused on how you create a trust. In Section A, we'll look at the bifurcation of ownership, and we'll talk about how that's the hallmark of a common law trust. Then we'll move on to Section B, where we'll look at the laws governing trust creations. Here we're going to discuss what is needed to find the intent to create a trust. We're going to talk about trust property. We're going to define what a trust beneficiary is. And finally, we'll discuss when a writing is required. First, let's discuss the sources of law. We discussed for wills and trusts, we would use something we often refer to a code called the Uniform Probate Code. Well, there is an equivalent code for trusts, and it is called the Uniform Trust Code. We'll refer to it as the UTC. This is the primary code that we're going to focus on, although at times we will refer to the common law rules because the common law rule may be more widely adopted than the UTC. Your book reviews the early restatements and the great treatises, which heavily influenced the development of the Uniform Trust Code. But the Uniform Trust Code has been adopted in more than half of the states. And so that along with the common law, are going to be our primary sources. When we talk about trusts, we typically categorize them as either testamentary trusts or inter vivos trusts. A testamentary trust is a trust that's created in the will. Because it's created in a will, it is considered a probate transfer because the will must be probated for the trust to be created. Because it is created in probate, it is irrevocable, meaning that the trust cannot be revoked. The second type of trust that we will refer to frequently in this course is an inter vivos trust. An inter vivos trust is a trust that is created while alive, right? Vivos, life. An inter vivos trust can be created through a declaration of trust or through the use of a deed of trust. The transfer is done outside of probate because it is done during an individual's life. So it's considered a non-probate transfer. It's also referred to as a will substitute because it can be used instead of a will to transfer property. An inter vivos will can be revocable, meaning that during the settler's lifetime, it can be revoked or changed, or it can also be irrevocable, meaning that during the settler's lifetime, it cannot be changed. And you will know whether or not it is a revocable or an irrevocable trust based on the language used to create a trust. A quick note about vocab before we move on. So, a decedent is referring to the person who has passed away. We use the term testator when that person has a will. Now, the person who is giving the property away, the person who is the current owner of the property, we call them a settler in the context of trusts. You may also see the term trustor used. To make things less confusing, I'm going to try to use the word settler. Trustor means the same thing, but because it can be confused with trustee, I'm going to try to stick to using the word settler. Now let's dive in and try to get a better understanding of what a trust actually is. When you have a trust relationship, you have three primary parties or groups of parties. You have the settler, you have the trustee, and you have the beneficiaries. The key to finding a trust relationship is that the trust separates the ownership from the managerial responsibilities of owning the property. So the beneficiaries receive the benefit of the property ownership. The trustee takes on the managerial responsibilities. We'll talk later about what these responsibilities are. They often include investing the trust property. So the settler gives the trustee the property to hold for the benefit of the beneficiaries. So again, the beneficiaries benefit from the trust, but the trustee is the one who manages the trust. Now, it's important to note that a trust is not a legal entity. All we have in this diagram are relationships. We don't have another legal entity like a corporation. A trust is not an entity. It is a fiduciary relationship. It bears repeating. A trust is a fiduciary relationship. Because it's a fiduciary relationship, there are safeguards that we put in place to help protect the beneficiaries from any mismanagement that the trustee may do. So when we're referring to a trust, what we're actually referring to is this fiduciary relationship or this trustee relationship. Now, because the trustee is managing the property, they're likely going to enter into contracts on behalf of the trust. and they might enter into some debts on behalf of the trust. The trustee could also enter into debts, personal debts, right on their own. Say those are creditors of the individual. Now, because a trust is not a separate entity, the trustee can be sued by these creditors, even though the trustee is transacting business on behalf of the trust. If the trustee is acting within their scope of their fiduciary duties, then the trust can indemnify the trust. So this trust here will pay the creditors or pay the trustee back for the costs that they accumulated. If, on the other hand, the trustee is transacting business on their own personal behalf, the creditors of the trustee can only go after the trustee in their personal capacity. They can't touch any of the trust property. So the trust's assets are separate from the trustee's personal assets. And that's where the bifurcation of ownership comes in, right? So the trustee has their own assets, their own personal assets. The trust assets, they're not owned by the trustee, right? The trustee is just holding them, managing them. And so they can't be reached by the personal creditors of the trustee. I'm going to quickly go over what the four primary functions for a trusteeship are. You can find them in detail on page 396 of your textbook. The first function is custodial, and that means the trustee takes custody of the trust property, and they safeguard it. So they keep the trust property. Another is an administrative function. This administrative function includes accounting, record keeping, as well as making tax filings and other required state filings. Another function is investment. So trustees are required to regularly review the trust assets and make sure that they are investing the trust assets like a prudent investor would. We'll talk about these standards in a later chapter. Finally, the trustee must make distributions. These distributions can be of income that is made by investing the assets, or it can be of principal if that is what the trust requires. Principal is the original property that was invested. These distributions are made to the beneficiaries. Before we move on, I just want to remind you of the fundamental differences between a testamentary trust and an inter vivos trust. Testamentary trusts are created by a will, and because they are created by a will, they go through the probate process. An inter vivos trust, on the other hand, is created during the life of the settler, and the property transfers during the life of the settler. So when I refer to these two types of trusts, you are now reminded of the difference. Let's talk about the creation of a trust. We said that a testamentary trust is created by a will, and then inter vivos trusts are created either by a deed of trust or a declaration of trust. A declaration of trust is where there is no actual conveyance of property, just the manifestation of intent by the settlor that they're going to hold their property as a trustee for the beneficiary. So the property does not exchange hands. What changes is the settler's relationship with the property. They go from being the owner of the property to being the trustee that is managing the property for the benefit of the beneficiary. This differs from a deed of trust. A deed of trust is used for real property. You may remember it from your property course. And a deed of trust actually conveys the title of the property to a third-party trustee. So we actually do convey the title. The property does exchange hands. Now, because the deed of trust involves real property, the statute of frauds applies. And that means that the deed of trust might be in writing. Because a testamentary trust is created by a will, the law of wills apply. And it means that the will must be in writing. However, there is not that requirement for an inter vivos trust that is created through a declaration of trust. A declaration of trust can be oral. Now that we've gone over those nuances, let's generally go over the creation elements. In order to create a trust, whether it be a testamentary trust or an inter vivos trust, you must have at least three of these elements. The first is intent. There must be intent by the settler to create a trust. The trust terms must also have definite or ascertainable beneficiaries. And the reason that we have that requirement is that we need to have someone who can enforce the trust. Third, we need to have specific property that is placed or held in the trust. And we've referred to that property as race. Now, there may be a writing requirement as well, and we said that if it is a testamentary trust or it's created through a deed of trust, then there may be a writing requirement as well. Now, the rest of this presentation, we're going to spend on going over and defining these three requirements. First, we're going to discuss in depth the element of intent. We're going to start with the case Lux v. Lux on page 401 of your text. This case demonstrates that there's no particular form of words that are needed in order to create a trust. The courts look to the intent instead of the specific words used. The intent that must be manifested is one that creates a relationship where the trustee holds the property for the benefit of the beneficiaries. So they're looking for intent, not necessarily to create a trust instrument, but intent to create the trustee relationship where the trustee holds the property for the benefit of the beneficiaries. And so what courts are looking for is evidence that the settlor wanted to create that relationship. At issue in Lux v. Lux is whether or not a testamentary trust was created. And the language in the bequest can be found on page 401. The relevant part states that all the rest of my estate I give to my grandchildren, share and share alike. Any real estate shall be maintained for the benefit of said grandchildren, and shall not be sold until the youngest of said grandchildren has reached 21 years of age. Okay. So in Lux, the guardian ad litem for the 5 grandchildren argued that the will made an outright gift of the land to the grandchildren. But the court disagreed. They said that there was an intent to create a trust. Even though there were no specific words that were used that indicated the trust, the settlor indicated she wanted the property to be maintained for her grandchildren and not sold because she realized that it could produce income. She had income-producing property. And so the duties of managing property and distributing the income are duties that are normally associated with a trustee. And so from that, the court found that the settlor intended to create a trust relationship. Now note, in this case, the settlor did not identify a trustee, but that's okay. A court is not going to let a trust fail because of a lack of a trustee. The court will just appoint a trustee if one is not named. Let's take a look at the next case, Jimenez v. Lee. At issue in Jimenez v. Lee is also whether a valid testamentary trust was created. In Jimenez v. Lee, the grandmother purchased a bond or bonds to provide for the educational needs for her granddaughter, Betsy. Betsy's father later cashed the bond and invested it along with some of Betsy's other money into bank stock. He gave himself the title of custodian of these gifts. Now, a custodian is another type of relationship that was recognized under state law, and it didn't carry the same responsibilities of a trustee. As a custodian, the father could use the money for whatever purposes he wanted to, as long as those purposes benefited the minor. He also wouldn't be responsible for the degree of bookkeeping that was required in the fiduciary role of a trustee. Also, if he were to be found a trustee, he would only be able to use the trust property for education purposes because he would have the fiduciary duty to use the trust property for the purpose of the trust. So at issue in this case was whether grandmother's gift was an unconditional gift or devise to Betsy, for which her parents served as, quote, custodians until she reached the legal age, or whether the gift was meant to be held in trust by her parents for her educational needs. The court found here that a valid trust exists because the grandmother intended for the gift to be held for Betsy and to be used only for the purpose of paying for her educational needs. Thus, the requisite intent was found. Again here, no specific words in trust were needed to demonstrate that intent. What's interesting about this case is the father had already cashed the bonds and closed the savings account. So the court had to trace the funds from the sale of the bond to the purchase of the bank stock. And then the court imposed a constructive trust or an equitable lien on that stock because the original race, the original trust property didn't exist. It had transformed into different property. Now, it's interesting also to note that because the father breached his fiduciary duty, the father owed whatever income would have occurred had there been no breach of trust. This provides us with a good stopping point, so we're going to finish off this video here, and we'll continue with the remaining trust elements in part 2.